Attorneys. My name is Angelique Jackson. I'm the Manager of Business Development over here at Charles E. Smith Life Communities. I'm standing in for our host, Deanna Ziamba, as her son, Kyle, graduated from high school. So we want to say congratulations to him. And then joining us is Coryn Rosenstock from Altman Associates, a division of Frost Law. And thank you so much for joining us. And do you want to tell us a little bit about what you do over there at Altman Associates?
Yeah, well, first, thank you so much for having me. Thank you to all of you for joining us for today's conversation. So what I do is estate planning and administration. So as a lawyer, we help people plan while they're alive for their loved ones, how decisions should be made for them, medical decisions, financial decisions for themselves, and how they'd like their property distributed in the event something happens to them. And then on the administration side, we work with people when a loved one passes away to help them deal with property, transfer assets, et cetera.
Okay. So, and then the topic is medical power of attorney and the medical directive. What exactly is a medical directive, and why is it so important that we have one?
So that's a great question. A medical directive is a document that you can create with the help of a lawyer, and not necessarily with the help of a lawyer, but it expresses your wishes about medical decisions to be made for you in the event that you can't make them for yourself. So medical decisions are, of course, among the most personal, important decisions that any of us make. We are lucky here that we can make our own personal medical decisions. And if we can't, because we're ill or due to incapacity, a medical directive affords you the opportunity to appoint someone to make those important decisions for you.
So what topics or what scope is under this medical directive? Is it the same as like a DNR, a living will?
Sure. So a medical directive typically contains two parts to it. So the first part is where you appoint the person to make medical decisions for you that you believe will make the right decisions for you. And you can name a backup person, or you can name multiple people. And the second part usually is something we like to call a living will.
Okay.
A living will talks about your wishes regarding different life-sustaining measures, extraordinary measures, as we sometimes call them, what you would like your loved ones to follow in terms of direction in case something is to happen to you and you're being kept alive. You can tell them what your wishes are beforehand. It can also contain your expression for what you would like, if you would like a funeral, if you would like a cremation, what you'd like done with your ashes. And it's especially important that if you do want a cremation, which many people it's something that they'd really like and they'd prefer, that you write those wishes down so that there is an authority in the state to have that cremation happen.
Oh, okay, great. And so if we don't have a medical directive, and you're telling us, and it sounds like it's very important that we should have one, how do we go about creating one?
So a medical directive is something, again, you can create it with your lawyer, or sometimes your medical provider might offer a form that they have. And it needs to be signed by you in front of two witnesses, and there are some rules about who the witnesses can be. And again, that would give you the opportunity to lay out your wishes regarding who should make medical decisions for you and how you want those decisions made. It's a very personal document. It's something that people should think a lot about because, again, these are very significant decisions. You had a question earlier about the difference between a medical directive and a DNR, a document like that. So in Maryland, there's something called an MOLST, a most, and that can contain a DNR. And what that is, it's separate from a medical directive, but that talks about whether you would like to be resuscitated, and it can order to a doctor. It tells a doctor that this is what I want you to do, doctor. It's not a direction to your loved ones as to how you would like decisions made, but differently, it's to a doctor. So if they come to your house, they can look at that most form and make decisions about should they resuscitate you, administer CPR, things like that. And a most form has to be completed with a nurse practitioner, a doctor, or a physician's assistant. So they have to be the one to help you fill that out versus a medical directive, which you can fill out on your own or preferentially with the help of a lawyer.
Oh, okay, thank you, that's interesting. So when we're talking about the state of Maryland, we have folks that, you know, travel a lot, and
Sure.
my parents live in Illinois.
Mm-hmm.
Do these directives, do they transfer from state to state?
That's a really good question. So under the laws of the U.S., essentially, if I create a medical directive in the state where I'm living, and it's valid under my state law, so it's valid under Maryland law, if I travel to Illinois with my medical directive, the laws in Illinois would say the doctors there have to respect what I've written in my Maryland medical directive, because it's Illinois, I'm traveling, I validly created it under Maryland law, so any state in the U.S. should respect my wishes.
Okay.
That said, we typically recommend to our clients that if they have moved, so if they have moved from Illinois to Maryland, that they recreate their medical directives and other documents in the format that Maryland likes to see, because each state actually has its own form.
Mm-hmm.
They have their own prescription for what they think they should look like. So practically, it's a little funny to say, but the doctors in Maryland are used to looking at the Maryland form, and the doctors in Illinois are used to looking at the Illinois form. So when you move, it might make it easier if at some point you can go to update so that it's more in accordance with what the physicians are used to seeing, so that there's no confusion when you actually go to present this to them.
Okay, so let's say, fabulous, I have a summer place in Florida.
Oh, that's,
Same
yeah.
as well, or
So
do we have two?
we have many clients who live in Maryland and also live in Florida, and I happen to be licensed in both Maryland and Florida. So for these people, we actually do create two. I create Maryland documents for them and Florida documents, and I say, keep your Florida documents at your house in Florida, and keep your Maryland documents here. So I think it is a good practice, especially if you live in both places, to get two of these done.
Okay, well, thank you, that's helpful. And then you mentioned, you know, that it's a very important decision, and it should be someone that you trust to make these decisions. And, you know, if you can't, do you have any tips on how to, you know, choose someone who's right for you, someone that you trust to carry out your wishes when you cannot?
Yeah, so like you mentioned, and I've said, and I can't drive the point home enough, it's really important that you pick somebody that you really trust to make the decision for you in the way that you would want the decision made. Mm-hmm. So if I, as a parent, have two adult children, and one of them, you know, I trust them both equally, I love them both, but one of them, you know, I know is more aligned with the way I look at medical treatment. Perhaps I'm really into holistic medicine, and that child really follows that standard of caring for themselves in their own daily life. And I have another child who is very smart, loving, and caring, but it just follows a different treatment plan. When I were picking my medical agent, I would go with the child that more follows my mindset when it comes to treatment, so that I know it would be easier for them to make decisions that are aligned with my beliefs, because they're aligned with my child's beliefs as well. I have a lot of clients who are concerned about picking one child over the other, or one family member over the other, because they don't want to offend anybody.
Right.
And that it's an important consideration. But I think that if you have a family that has good communication, you can explain why you've chosen one over the other to make decisions. If you don't create a medical directive, what is going to happen? Who will make the decisions for you? I mean, it's a really important point. So the law, Maryland law, in every state has an order of priority. You may or may not like who the state chooses. So the first person the state would choose is if someone has gone to court to get a guardian appointed for you. Usually not the case. So that's someone went to court and had somebody appointed as your guardian. That guardian would make decisions. But if it wasn't a guardian, it would be next in line your spouse or domestic partner. Next in line would be your adult children, all equally capable of making the decision.
Oh, okay.
So they might fight with each other. Then after that, it would be your parents, if they were alive, or your parents. And then after that, your siblings. So you may not like the order. And if you don't name somebody in a medical directive to make decisions for you, and it can be a friend, I mean, it doesn't even have to be a relative. If there is argument and you haven't appointed anyone about who should care for you, and I've seen this happen, people do sometimes go to court, and they argue it out in court while their loved one is really in need of care, and it's pretty awful. So we really, we really like for people to make the decision while they can, while they're confident to do so, so that, you know, people can focus on loving their loved one and caring for them instead of arguing in a courtroom about who should be making these very personal decisions.
Right, because it would be very stressful, you know, in the case of, you know, loved one in the hospital, critical care, and everyone's, you know, fighting about, you know, what should be done. So this is a way, it sounds like, that you can still have your say, you know, still have the independence to make decisions even when, you know, you physically can't.
Yeah, that's exactly right. And the emotions really run high, because if your loved one is sitting in the hospital and you've come to a critical point where you're like, should we continue treatment? Should we not continue treatment? And the family can agree, and the siblings or whoever it might be, I mean, they're fighting with each other. They're bringing up all the past conflicts, even from when they're kids, if they don't get along. And they are, it's difficult. And they spend a lot of money on lawyers, and it's really tough to see. So we really like for people to just make the decision beforehand, so that hopefully, you know, their loved ones can again focus on caring for them instead of fighting with each other.
Yeah, agree. That's very important. So is there any instance, or is there anyone who's ineligible from being a medical agent?
So usually somebody who, if you're being treated at a healthcare facility, or you're living, for example, in an assisted living community, you usually cannot appoint an employee who's working there to be your medical agent. I have seen clients who they don't have any loved ones to appoint, and they appoint their medical doctor who's outside of that care setting, and that's something you can discuss with your personal physician about whether he or she would be willing to serve in the role. But you typically can't appoint somebody who's actually within the facility.
Oh, so if I'm, you know, it comes to the point and I'm living at an assisted living because I need some help with my activities of daily living, and I become very close with my aide there, who I see every day. So they are ineligible to become a medical agent for me.
Typically, yes.
But my primary care physician,
if they weren't within the setting of that facility.
Oh, so if they don't, they're not in the facility at all, but they're just my primary care down the road.
Then they can be appointed.
Okay. Oh, that's very interesting. Have you ever seen an instance where, you know, someone who is trying to create a living will or a medical directive, and whomever that they've appointed says no?
That's really, you know, I haven't seen anybody actually say no. I've had instances where a client has appointed potentially their spouse, and their spouse just feels at that time like they can't make these decisions. It's too heartbreaking, it's too overwhelming. Maybe they're dealing with their own health issues at the time, and so they resign, and the next people that have been appointed as the successor would come up to make those decisions for their parent or family member.
And so then, once you've completed this directive, it's important that you share it with your family.
Yes. So typically what we say is, you know, keep the document in your house, tell your loved ones or the people you've appointed where it's located. It's a really emotional subject to talk about in the context of some families, and they don't want to bring this up with their children, because their children can't even fathom the concept of something happening to their parent. Even some parents themselves don't want to consider these possibilities. So we say, you know, you can keep it in your closet, keep it in a safe place. Just say, go here if something happens to me. If you have really strong wishes about your treatment, especially about, you know, whatever it might be, you might want to share it with your doctor, but it's not necessarily required that you do so before the time comes that it's needed.
And that's what I was going to ask you. Is this a document that, again, we should share with our primary care physician, and should he have a copy, he or she?
So typically, primary care doctors do say that if you have one, give it to me and I'll keep it on file. And that's something you can talk about with your lawyer about whether you think that would be, whether you should or shouldn't. But a lot of our clients do share it with their primary care doctor.
Okay. All right. And then, is there any instance that they shouldn't?
That's a good question. I think that if there are I'm not sure. There may be some cases where you might not want to share it, but until the time comes that it's actually necessary, or you might just want to keep it in the hands of your loved ones. So.
Okay, yeah, because some people might ask, once my physician knows about my directive,
Right.
will they still,
Honor the wishes of
honor my
agent.
wishes? Yeah.
Yeah. So that is an interesting question. Is the medical directive is really a directive to your loved ones as to what should be done with regard to your treatment. So some people feel like I want to keep that within the context of the family and not share it with the doctor, just so that the doctor's making independent decisions from my family members. And
Okay.
yeah,
that makes a lot of sense. And things change over the course of our lives. What if we wanted to change this directive? Can we do that?
So it's fully revocable. While you are competent and able to make decisions for yourself, you can change your medical directive. You can revoke it completely either by marking it up, scratching it out, saying null and void, ripping it up, destroying it. These are all valid ways under the law to get rid of your old medical directive. Or you can create a new medical directive that simply states that you revoke your prior document. But the important thing is that if you revoke your document, you have to let the people who have the document know that it's no longer valid.
Okay.
Otherwise, they can rely on it. So if you provide a copy to your physician and then you've decided you no longer want those wishes followed, you have to then tell your physician, I don't want that document to be valid. Here's the new one. Okay. Otherwise, they might rely on the old.
Okay. Okay. So it is changeable.
Absolutely changeable, which is why we say, we'd really like you to do your planning now, even though it might be stressful and it might not be a task you want to complete, just do it. And then if you change your mind after, we can fix it, we can amend it, but get something down in writing now so that at least you have a starting point.
Now, typically, is there an age that you recommend that you start these directives?
Yeah, so funny enough, as soon as you turn 18 years old, you are a legal adult. And your parents no longer have the authority to make medical decisions for you. So we have, as early as someone turns 18, we have parents bringing their kids in to get these documents executed.
Really?
Especially when they're going off to college. The mom and dad want to be sure that we have the ability to be appointed in case something happens to my child. And we also typically execute in that context like a financial power of attorney as well. Okay. For a young person.
So what would be the difference then between the medical and the financial power of attorney?
So the medical power of attorney is strictly for medical decisions. The financial power of attorney is a separate document, and that appoints someone to make financial decisions for you. And you can specify which decisions you want made, how broad of power you want to give to that person. And the financial person might be different from the medical person you appoint.
Okay.
Maybe one of your family members is better with money, and one of them is better with medical stuff. So you appoint two different people.
Okay, yeah, because, you always hear a broad term of, power of attorney.
Right, POA.
And so it's important to make those distinctions between medical and financial.
And when you're looking at all these documents in front of you, it is actually confusing to know which is which, and you have to look for these special words like medical, but they both say power of attorney typically, so okay. It can be hard to decipher.
Thank you so much for that distinction. And it looks like we have a question. And so the question is, what's the difference between a POA and a living will?
Oh, yeah, so this actually fits in perfectly, which is that the living will is the portion of a medical directive where you state your desires regarding life-sustaining measures. Okay. I know that's a mouthful, but it typically says, do you want to be kept alive on machines? Do you want to have IV or feeding tubes administered in the event that you are in a medical condition where there's no hope? And we sort of specify it, we lay it out more practically and more specifically within the context of the living will. But the living will is the portion where you say how you want treatment to be administered, and the POA is a shorthand for power of attorney. When people say power of attorney, they tend to mean financial, but it again also applies in the medical context. You appoint a medical agent or your medical power of attorney to make the medical decisions for you.
Okay, and so then in the living will, again, this is where we can also choose to be cremated or donating our body to science when we pass.
Yeah, that would, it wouldn't be necessarily contained within the living will portion, but within the broader context of the medical directive, where you can say your wishes regarding cremation or a funeral, how you'd like to be buried, if there's a burial plot that you've already established for yourself. You can also indicate your wishes regarding organ donation. So in Maryland, most people are familiar, they think they want to be an organ donor and they put it on their driver's license. But there are other ways to indicate that you're an organ donor through a writing that's not your driver's license. And one way to do it is in the medical directive.
Okay.
To say, I allow my agent to make gifts of my organs.
Okay. And then, the power of, when they have medical power of attorney, in the event that you are not decisional, then they would make the decision, let's say at the hospital during critical care.
Yes, that's right.
Okay. Do we have another question? Okay.
About
two different people have different privileges. How and when do you explain to them in advance? Are we talking about maybe one we've appointed as the financial power of attorney and one as the medical? That's a good question.
Yes.
Thank you.
So I get this a lot from clients, which is, should I tell my family about the planning? And it really, my answer is generally yes. I think it's better to explain while you can what your wishes are so that people's tensions don't run high after you're no longer able to explain, because then they say, Mom loved you more, Mom gave you this, Mom appointed you in this position, and that's not what Mom is thinking. Maybe Mom was just thinking, well, I love you both and you're the older one, or I love you both and you live near me, or I love you both, but son, you're really good with medical decisions, and daughter, you're really good with financial decisions.
Right.
That's why I put you in different places. So I think it's a good idea to talk about it with your family, but we have had situations where some folks are estranged from their loved ones, and in that context, you might not want to discuss it with them. It really depends on the family situation.
So what about when you're a child of someone? So myself, I have two parents that are aging, and they don't have any medical directive. Do you have any tips on being able to sensitively bring it up?
It's a really tough conversation to have.
It really is, and I'm dreading it myself, but I know it's something that it has to be done.
It's a really tough conversation. I think the easiest way to bring it about is to say, listen, I think that we should go, talk to a lawyer and talk about, like, who's going to make the financial decisions for you, because that's really the financial decision. Nobody's allowed to access your account unless they're actually on your account. There's no way for them to get into, for example, my parents, unless I'm under the age of 18. But once I turn 18, nobody can access it. So what happens to your mom and dad if they can't write a check for themselves and you need to be able to make a payment for them?
Right.
So you say, Mom, Dad, we need to go to the lawyer and we need to talk about getting a power of attorney so I don't have to go to court to get appointed to help you with your financial accounts if something happens to you. And then you go to the lawyer and the lawyer will help you out and say, not only do you need a power of attorney for financial decisions, but we should talk about your medical directive. We should talk about your will. And I think that's a really easy way for a child to bring up a conversation with their parent. Just get them thinking about these questions even. And just say, Mom, do you know what your medical wishes are? Can you tell me what they are? And she might say, I don't want to talk about it. But maybe in a month, and maybe in a month from now, if you keep prodding, you can send her an article, say, think about this, Mom. I mean, usually in an emergency situation, the physicians will follow the wishes of the loved ones that are available. But the medical directive covers a broader range of decision-making than just in the emergency context. That's why the financial power of attorney is really the easy way, because I can tell you, it doesn't matter what type of emergency is happening. The bank will not let anyone access an account unless there's a power of attorney or an order of court or your name is actually on it.
So in the event that there isn't a financial power of attorney named, so then the process would be we would have to go to court in order to access our parents' funds.
Because unlike with a medical decision where the law will default to decision makers, the law does not default to any decision maker for finances. So if I don't create a medical power of attorney, Maryland law will give an order of priority to the physician for who they should listen to. But if I don't designate a financial agent, there's nobody that can help me other than a judge appointing a loved one to do this for me, or myself actually physically creating this power of attorney.
Okay, so it's probably a very long process when, you know,
The
things.
court process is very long, sometimes drawn out. It's at the wrong time. Maybe your parent is immediately needing of help, and the power of attorney process, unless you do it under an emergency proceeding, can take months.
Okay, all right, well, that's,
Yeah.
I guess that's a good segue.
Yeah.
Because I've tried a couple of times. And,
Yeah.
yeah, she's just not interested in the conversation.
Right. So maybe you bring it up by saying, you know, let's talk about, like, how can I help you pay your bills when the time
Right.
comes? Like, what happens if we need to sell your house and you can't because you can't make it to the closing because of COVID or whatever it might be? Like, let's get you a power of attorney written, and then the attorney will talk about the broader range of estate planning documents, which will always include a medical directive.
Okay, all right, well, that's helpful because, you know.
It's a tough conversation.
Very tough. And I see, we have another question. And let's see here. If a family disagrees with a person about care needs, and the person has never completed any documents and now has dementia, but still has capacity, do you ever use mediation?
So this is an interesting, I'm wondering, so there are a couple of things. You are always allowed to make medical decisions for yourself, as long as you have the mental capacity to do it. So even if I create a medical power of attorney, just to be clear, it's only really effective if the doctors think I can make decisions for myself.
Okay.
Now, in the context, it sounds like in this case, perhaps the person, him or herself, does not have capacity to make a medical decision, because again, if they did, those wishes would be followed.
Well, maybe they are speaking of maybe in the early stages.
In the early stages.
Of dementia, are you still able to effectively appoint someone?
So that's another interesting point. So legal capacity is different from medical capacity.
Okay.
So a medical doctor might find that a patient cannot make decisions for him or herself, and they have guidelines for determining whether or not they're capable. We as lawyers have a completely different set of guidelines, and we believe, and the law gives us the authority that if somebody, for example, is in the early stages of dementia, as long as they know some very basic things, who are their loved ones? What are they doing in my office? What is sort of the nature of their property? Do they have a house? Where is it located? What's sort of the nature of their bank accounts? They don't need to know everything in the world. But as long as they know some basic things,
okay,
I can determine that they have capacity to make the decision, and then I can help the document get drafted. It is something that we are very aware of, and we document properly when we meet with people to make sure that they have the ability to make the decision. And
okay, so that's one way. So it's like you do have
there's
an
a window,
assessment of some,
right,
to assess capacity.
Mm-hmm. So even
Even
if someone comes in and they say, my doctor says I have dementia, that doesn't mean I can't help them. I probably, in many cases, still can help them if they are in the early stages or, you know, can still make decisions for themselves.
Okay, and then I guess it's a two-part question.
No, that's it.
Okay. Oh, I'm sorry.
That's okay.
I guess there was a question about mediation. Have you ever had to do that?
We haven't done mediation. We've had some court cases with dueling family members about who should be appointed as someone's medical guardian, but that's only after the person is no longer has capacity.
Okay.
If the person has capacity and somebody is trying to become guardian of them, the judge is like, bring them to court, and the person comes to court and they say, I can still make decisions for myself. Why is somebody trying to?
Okay.
But in terms of family members disagreeing over the type of treatment that should be given, I haven't actually seen mediation. I think that in the context of a court case, again, where there were dueling family members, it might make sense to have mediation so that siblings and parents could try to work out amicably the decisions that should be made.
Yeah, because I'm pretty sure there have been instances where maybe the family, you know, the person making the decision, the loved one says, no, I don't want to, you know, don't put me on any machines or intubate me, and the children are not okay with that decision.
Right. I mean, because it's tough, you know, you might think, you know, I'm at peace with the decisions I've made, but your family members might say, we want you to stay alive as long as you can. But as long as you yourself can tell the doctor what you want, the doctor will listen to you.
Okay. Thank you. Yeah, that was kind of like a tricky, because that, you know, I'm sure you've seen that happen a time or two.
Yeah.
And then I did have a question about, like, let's say there's no close family. Who can you appoint? But we did talk about physician, and then you did mention guardianship.
Right.
Could you explain, like, maybe an instance where that would take place?
Yeah, sure. So in terms of who you can appoint, you can think about maybe a medical doctor, or if you have a close friend, you can appoint your friend to make decisions for you, and a backup friend. Guardianship is really in the case where there are people fighting over who should make the decisions, because again, the law will say, gives an order of priority. So if I haven't appointed someone to make medical decisions for me, the law has a default list of people, and at the very bottom of the list is actually a friend. A friend could show up to the hospital, write like an affidavit, and explain that you're friends, and et cetera, and the doctor would probably listen to them. But when we have people fighting, and they're in the hospital, I think the doctors have certain requirements of referring it to certain committees within the hospital, and the committee will probably recommend that they get a court order to say what should be done in terms of treatment. There are times when you would get guardianship for medical reasons for an individual. Usually this is in the case of a disabled adult child.
Okay.
So if you have a child who is a person over the age of 18, so the parent is not legally allowed to make medical decisions for them necessarily, they might go to court and get appointed as guardian of the person if that child doesn't have capacity to make the decision to sign the document. It does happen, unfortunately, that this is the case. We have children who just are not capable of making legal decisions for themselves and signing the document. So we go through this court process, and the court is very amenable. I mean, when there's no argument about who should be appointed, the court makes it happen as quickly as possible, and the hearing is like 5 minutes, and they meet the parent, and they say good luck, and yeah,
because you know, I always think about aging population when I think about a medical directive, that, you know, I do have a child who's in Florida, so maybe you can help me.
Right, yeah, absolutely. Yeah.
This medical directive.
Yeah, with our young clients, it's interesting when they come in. We have these college kids, and they're so new to the world, and I'm like, well, now is the time when you're a legal adult. I know it doesn't seem like it because your mom and dad are there for you all the time, but if you want them to still be there for you, we have to actually appoint them in these documents.
Yes.
Yeah.
Because anything can happen.
Anything can happen.
Yeah. So there's another question from Barbara. Thank you so much. She says, what happens if a spouse becomes incapacitated or dies without a financial POA? Some assets are joint and others are not.
Okay, so a financial power of attorney is only effective while the person's alive.
Okay.
So in other words, after a person passes away, their assets are locked unless there's a joint owner, as you had mentioned, or there's a beneficiary. So if I pass away and I have a checking account in the name of Coryn Rosenstock, nobody's entitled to access that account if there's no joint owner. Like maybe I'd be joint with my mom or dad, but I don't have a joint owner, and I didn't name a beneficiary. So it's just the Coryn Rosenstock account. And
so I'm sorry, but so the financial POA does not? Wow, that's interesting.
Yeah, so it only works while I'm alive, the financial POA. After I pass away, the document that takes over is my will.
Okay.
And my will name an executor, or what we call in Maryland a personal representative. And that person would have the authority to access the account and to distribute the funds in accordance with my wishes. And that whole process is overseen by the court, unless I have avoided the court by creating something called a trust or doing some other type of planning. So if I pass away with a joint account, it immediately goes to the surviving joint owner.
Okay.
The joint owner goes to the bank with a death certificate, and the account gets transferred over to the surviving owner entirely. But if there is no joint owner again, then there is this process, because if I go to the bank will say, well, this person's passed away, and
Right.
we don't know who the account is supposed to go to.
Right.
That your neighbor could walk in and say, you know, my neighbor passed away, can I have their account? And the bank's saying, no, what are you, crazy? Go to the Register of Wills and get appointed as the executor. And that's a whole other slew of issues, because the question is, who was there a will? Who has the authority to be appointed? Where do the assets go? And no, they don't automatically go to your neighbor unless you actually specify you want them going that way.
Okay, so it's just another way to protect your assets.
And that's all part of estate planning. So if you do go see a professional to do a medical directive, they'll talk to you about the medical document, the financial document, and the will, which would govern after you pass away.
Okay, so I think that we could probably do a whole show on financial.
Yeah.
POA and all the things that are, you know, kind of go with that. I do have a question though, it's like off topic a little bit.
Yeah, absolutely.
I'm just really curious about the assisted suicide. Some states are allowing this. Is Maryland one of them? And can you tell us a little bit about that? And is that something that could be added to the medical directive?
Yeah, so assisted suicide is a controversial topic for many reasons. And each state is making a decision about whether they would like to grant people the authority to do that,
Right.
to make those medical decisions. Maryland has not allowed for assisted suicide, but for example, DC does. And the law is very detailed. It is a decision that only you can make. And you can't actually put it in your power of attorney, because the person you name to make medical decisions for you will not be allowed to make that decision.
Okay.
Only you yourself can. And there are many different ways that the state will determine that you're even capable to make the decision, because they take it so seriously. But it's a great question.
Okay.
So your medical agent, although they are capable of making a whole range of medical decisions for you, would not be allowed to make that decision.
So Maryland is not one of the states that offers this.
Correct. So it's not even an option here.
Are they, I was gonna ask, are they thinking?
if I recall, I do think that there may have been a bill presented a few years back. I think maybe around the time DC was considering it, and it was shut down. But bills get brought up all the time and they get turned down. I think as culturally America changes and each state's opinions change, you know, it might be different a few years from now, or it might remain the same.
So you mentioned that there are certain things that must be met to determine that you do have capacity to make that decision. Can you elaborate on
Yeah,
what
sure.
those things are?
If I recall, pretty typically these laws will require psychological evaluation, although don't quote me on that, because again, I'm a Maryland and Florida lawyer, but I believe you need to go through some kind of psychological evaluation, and there's a waiting period, and there's a certain type of disease condition that would qualify you for this type of choice. So you have to be in a condition where it's terminal, and I think that there would be no hope, and that, you know, so they want to be sure you're capable of making such an important choice.
Okay, thank you so much. That's just something that I was, because coming from, you know, Illinois, and then learning that DC was one of the states, it's just something. And then I'm sure we do have some folks that do live in the DC area. I just thought it was an interesting topic of conversation, perhaps.
Absolutely.
And then there's another question here. Thank you so much. How has COVID affected power of attorneys, and has a lot changed in the last 18 months since we've seen COVID? Yeah,
so I think that COVID, you know, we added actually like a potential provision people could put into their power of attorney about how they wanted to be treated during COVID. Did they want to be put on a ventilator or not, as a direction to your loved one as to what they can do. I think it caused a lot of people to consider that they need to appoint someone to make decisions for them. We had a lot of people calling in, wanting to update their documents, wanting to get documents done, and there was a period of time where we were pretty easily able to do this remotely, so we could Zoom with our clients and we could have them sign over a video conferencing, not necessarily Zoom, and we could watch them and witness those documents. So there has been a rush for people to get their documents in place and make sure things are finalized the way they want it, because it became so important. So, and it was I was going to ask how challenging was that, since, you know,
the orders of distance, but.
Yeah, well, we still had clients coming in. We had some clients who wanted to do it virtually. We had others who wanted to do it through their car. So, we would come downstairs and we would pass papers to you through your car window, and that made people feel comfortable, whatever the client needs to make them feel comfortable. And then in the conference room, we had, a plastic shield. We were sort of like tossing papers feet down the table so that we weren't actually getting close to the client and all wearing masks and all distance and limiting the number of people who could actually sit at the table together.
Oh, wow.
Yeah, so we kind of developed our own procedure for keeping people safe and happy to the greatest extent we could.
So you had to be pretty creative.
We used to all sit at one table, because the signing of these documents takes a lot of people, because you need the individual signing, and we typically have 2 witnesses and a notary.
So 2 witnesses and a notary.
So that's at least 4 people. And then you add in like the spouse, and that's 5 people. And then you add in some children, and you have like a whole room full. So we would keep the client to the very end, and I would sit at one end, and we'd keep the witnesses outside the conference doors, and we would.
Very coordinated process.
Yeah, we had a very coordinated process.
So would you say percentage-wise, how much of an increase did you see with folks trying to get their medical directives in place since COVID?
It was, I think we thought people wouldn't be we weren't sure how it would go. I mean, I think in the beginning people were reluctant to come have legal services completed because it was just not the first topic on their mind. I mean, they were in a panic because of COVID, and then the next thought was, let me update my documents. So I would say, I don't know if I could put a percentage on it, but we've been very busy, not only because of COVID, but because of some of the political changes that are happening and some changes in the state laws that might be occurring. So it's been a busy time. Very busy. Yeah.
And we have another question. Is that a short one? So Barbara wants to clarify her previous question. If a spouse has a bank account in his own name and passes, will it not automatically revert to his surviving spouse?
Automatically, no, it will not revert to the surviving spouse, unless the surviving spouse is the beneficiary on the bank account. So if it's solely in the name of a person with no beneficiary and no joint owner, there is no automatic reversion. Somebody needs to be appointed in the court to be the executor, and then they need to follow the orders of distribution under the will or under the laws of Maryland that say if you don't have a will, where property goes, and then you need to tell the court how the property will be distributed. There are some states where, so that's Maryland, but there are some places where if the bank account was small enough, you might be able to do something called an affidavit, which is a sworn statement, and say, I'm the surviving spouse or sole heir or whatever it might be under the law, and that might avoid the court process entirely. That's not available in Maryland for a bank account.
Oh, so that's not available? Not
here.
So the turnaround process for this is probably quite lengthy.
It can be.
Yeah.
It can be.
So thank you for that question. And then we have another, are DNR forms part of what you do for your clients?
So we don't do a DNR. In Maryland, it's typically called an MOLST, but it's the same, very similar concept. A DNR or an MOLST can only be completed with a medical provider, usually your physician, or it might be a physician's assistant or a nurse practitioner. The reason why is that type of document is an actual medical order. So that authorizes the medical personnel to make decisions on their own without listening to any family member or loved one, because they consider that I have already told them what to do. I have already told you I don't want to be resuscitated, so the doctor has it within his authority to not resuscitate me, and they don't have to ask anybody about what procedures they will complete, because I've already told them in an order that's been signed by another physician or, again, an NP or a PA.
Mm-hmm.
So again, we can't complete those, but we do the medical directive, which gives authority to a loved one to tell the doctor what they'd like the doctor to do.
So then do you recommend your clients have both in place? And how would they work together?
Yeah, absolutely. We recommend that a client have both in place. What we typically do is we just ensure that when we draft our medical directive, it's in accordance with the wishes that they've expressed in their MOLST or DNR form, so that there is no inconsistency. There shouldn't be, because presumably their wishes should be the same in both places. I think in Maryland, for the MOLST, they specifically say, like, put that on your fridge or by your nightstand, so that the emergency personnel have to come into your house. They know to look in those places to see what they're supposed to do.
Now, do you guys ever make recommendations of filling out the MOLST form when you recommend that? Is there an age?
We don't usually make the recommendation on our own that people complete them. It usually is only brought up in the context of a client asking. I have only seen these forms done for people who are elderly in the aging population. They typically have very strong wishes about what they want to happen if they need to be resuscitated and in those really extreme contexts. So that's where I've seen a MOLST form be completed.
Okay. So usually with chronic illnesses,
yeah,
they're very detailed.
Right. Because again, it's an order about what you want happening, because if I tell my loved ones what I want to happen, even if I write it out in the medical directive, sometimes the loved ones won't actually follow what I've written, and I've given them the authority sort of to make their decisions on their own, despite even providing them recommendations. So again, if in my medical directive I appoint a loved one to make medical decisions for me, the law will respect what that decision maker is deciding. It won't necessarily read the other stuff I've written in there. The other stuff I've written in there is really a recommendation to my loved one as to what I'd like them to do.
So they can still act in their own behalf.
Right, which is why it's important that you name someone who will follow your wishes.
So in that event, there's a medical power of attorney, but there's a MOLST form complete, and they make decisions that are, different from what you've outlined your wishes on the MOLST. So then the physician will the MOLST form uphold?
The MOLST form, I believe, and I don't actually have a ton of experience with this, but the MOLST form is most effective in an emergency situation. I think when personnel don't necessarily even have a chance to ask a loved one what should happen, and they just see the form and they follow what the form will say because they have the legal authority to do it, so they don't necessarily need authority from anybody else.
Okay. All right. Thank you for that. And then do you have any tips, any other things that we should maybe know about when creating a medical directive?
Yeah, I think that it's something that you should, even if you create it, you should look at it periodically to see if your wishes are still as they were. We recommend that people look at these documents every 5 or so years. And you may have changed your wishes, you may change who you want to make these medical decisions for you. So it's an evolving process. Just because you sign it one day doesn't mean that in the future you won't change your mind. I just would reiterate that even though it's an uncomfortable topic, it's an important one. It's an important document to complete. Talking about it with loved ones is difficult, but I think if you bring it up little by little, it might be a good way to ease them into it.
Yeah, okay. Thank you. Does anybody else, please feel free to ask any questions?
Yeah, we want to leave some time for you guys to type in anything that's on your mind.
We want to hear from you guys. What's important? So we kind of talked about who's ineligible, so we spoke about that. We spoke about disclosing to our family members and when we should. It's a very important thing to fill out, even if you have a child in college.
Yeah.
So that was something that was.
And usually the parents think about it like right before the kids are heading off to, and it's usually our existing clients, and they call us and say, Sally's going to school next week. So we do it really quickly for them, and then we talk to Sally, is this really what you want? You want your parents to know everything about, because we also complete a Hipaa release form, which is sort of a a companion form, which HIPAA, as you know, is the medical confidentiality law. It says your doctor can't release information pretty much to anybody unless you tell them it's okay. So we like to have our clients sign that they grant authority to anyone they've named as their medical agent. So if I'm naming you to make my medical decision, sure, the doctor should be able to talk to you, and then sometimes they add some additional people. So some of our younger clients will, they'll add their mom and dad or their grandparents, some of their siblings, even though like a younger brother or sister may not be able to make a decision for their older sibling, they want them to be able to get medical information if something happens.
Oh, so that's a very important piece, the HIPAA release, because that's something that's very real. And so I didn't even realize that, that should be attached to that with every, agent.
Yeah, so typically, like, as part of a general estate plan, we'll do at least a will, sometimes trust planning, and we'll do a medical power of attorney, a HIPAA release form, and a financial power of attorney.
Okay. So those are all, so that's very
part
important.
of the package of having the documents completed.
Are there any new laws related to this topic that we should be aware of?
Good question. So Maryland, the most recent change that's significant is actually from quite a time ago. It's in 2010, Maryland updated their financial power of attorney laws, and they said if you create the document in the 2010 law version format, it may have a little bit more power. So if anyone has documents from before 2010, we especially recommend that they update so that we can make sure they conform with the law. Medical Directive, there have not really been significant changes.
Oh, there hasn't?
Recently, no.
So nothing new, huh? But there's plenty to talk about on the financial side. That should really be a topic.
So I have a question.
Oh.
Which document overrides bank account beneficiary? Will beneficiary, so which is the priority? If my bank account has a beneficiary designation, that is what will bind. So it doesn't matter if I have a will. So if my bank account says I'm leaving the funds to my neighbor, but my will said leave it to my mom or dad, the bank account is going to my neighbor. So that's why it's actually beneficiary designations on accounts, on retirement accounts, on anything are always important to update, because sometimes you start working with an employer and you name somebody, or you open a bank account when you're younger and you might even have like an ex-partner on there, and that's what governs, not the will.
So that's very interesting, because I never even think about that. There's so many little facets of on the financial side, and just where your money should go, when you die. And so it seems like you've got to be very organized and really plan.
One thing that's an important distinction is the person who is your financial power of attorney will be making payments for your medical care. So if you name one person to be a medical agent, that medical agent will go to the person you name as your financial agent to say, like, can you write the check for this care? Can you write the check for this facility? So the medical power of attorney doesn't give any authority over finances, but the financial power of attorney gives that person authority to pay for medical treatment.
So have you ever had an instance, and I guess when they were talking about the earlier question, the mediation, where there is a little bit of friction between the medical and the financial, and the medical is asking for, maybe they have different opinions. Maybe the medical is acting on mom or dad's or the loved one's behalf, and the financial power of attorney is not in agreement with that. Do you ever see disagreements like that?
So I haven't actually seen a disagreement, but I did have this question from a client recently who said, well, if my medical agent wants this treatment, but my financial agent doesn't want to pay for it, what would happen? And I mean, it could get messy. The medical agent might have to get a lawyer, write a letter to the financial agent and say, you're required to make these payments because I'm authorized to make the decision. So it could get sticky, but I haven't actually seen it happen.
Okay, yeah, because that could be sticky. I'm just thinking of all the ways that little fires could burn. We have another question. Will outstanding nursing home expenses trump estate assets?
So, when you pass away, you might you might die with debt, so you might have outstanding bills that need to be paid. And the way that works is that the nursing home, for example, could become a claimant against your estate assets. So they file a claim in the court, and depending on what assets are available, maybe you don't have assets available to fully pay the nursing home, but creditors take priority over people you want to give your assets to.
Really?
So yeah, there's like an order of who you pay first and how they get paid and what percentage if there are not enough funds. So in that regard, yes, there's a time period in which they have to make a claim.
Oh, goodness.
Yeah.
Oh, wow. So it can really get maybe pretty.
It gets complicated.
On the financials, I think we have a lot of information that we could discuss on the financial.
Maybe we can do a follow-up.
Now, we're going to be wrapping up here soon. How can they reach you?
Oh,
Correct.
sure.
Now we want to get prepared.
Yeah, absolutely. So again, my name is Coryn Rosenstock. I am a senior associate at Altman Associates, which is a division of Frost Law. I know it's long and complicated, we just merged, but you can just Google my name and you would find me pretty easily. You spell it Coryn. But any lawyer who does estate planning should be able to assist you with these documents, but you want to be sure that you meet with a lawyer who's licensed in the state that you're living. So if you live in Maryland and you're a Maryland resident, you want to meet with someone licensed in Maryland to help you with this document.
Okay, thank you for that.
Yeah.
And if there's no more questions, we're just going to wrap up this week's episode. Thank you so much for everyone who attended. We really appreciate it, and thank you, Coryn,
It's my pleasure.
for joining us.
Thank you so much for having me. I've really enjoyed it. Thank you for all of those who have joined as participants and for asking your questions. Again, you're always welcome to reach out to me. I'd be happy to talk with you over the phone or over email. So I hope you enjoy the rest of your day, and I hope it's been informative.
Yes, thank you, and hopefully maybe a part 2 for the financial
Right.
side. Thank
Definitely.
you.